The Fair Debt Collection Practices Act is amended by Public Law 109-351, Section 801-02, 120 Statistics 1966-2006. As a public service, the staff of the Federal Trade Commission (FTC) has prepared the following complete text of the Fair Debt Collection Practices Act FDCPA, 15 U.S.C. Section 1692 to 1692p. Please note that the format of the text differs in minor ways from the U.S. Code and West's U.S. Code annotated. For example, this version uses FDCPA section numbers in the headings. In addition, the relevant U.S. Code citation is included with each section heading. Although the staff has made every effort to transcribe the statutory material accurately, this compendium is intended as a convenience for the public and not a substitute for the text in the U.S. Code. Table of Contents. Section 801 Short Title. Section 802 Congressional Findings and Declaration of Purpose. Section 803 Definitions. Section 804 Acquisition of Location Information. Section 805 Communication in connection with debt collection. Section 806 Harassment or abuse. Section 807 False or misleading representations. Section 808 Unfair practices. Section 809 Validation of debts. Section 810 Multiple debts. Section 811 Legal actions by debt collectors. Section 812 Furnishing certain deceptive forms. Section 813 Civil liability. Section 814 Administrative enforcement. Section 815 Reports to Congress by the Commission. Section 816 Relation to state laws. Section 817 Exemption for state regulation. Section 818 Exception for certain bad check enforcement programs operated by private entities. Section 819 Effective date. 15 U.S.C. 1601 Note Section 801. Short title. This title may be cited as the Fair Debt Collection Practices Act 15 U.S.C. 1692 Section 802. Congressional Findings and Declaration of Purpose. A. There is abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abuse of debt collection practices contribute to the number of personal bankruptcies, to marital instability, to the loss of jobs, and to invasions of individual privacy. Existing laws and procedures for redressing these injuries are inadequate to protect consumers. C. Means other than misrepresentation or other abusive debt collection practices are available for the effective collection of debts. D. Abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means and instrumentalities of such commerce. Even where abusive debt collection practices are purely interstate in character, they nevertheless directly affect interstate commerce. It is the purpose of this title to eliminate abusive debt collection practices by debt collectors, to ensure that those debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent state action to protect consumers against debt collection abuses. 15 U.S.C. 1692a Section 803. Definitions. As used in this title, when the term Commission means the Federal Trade Commission, the term communication means the conveying of information regarding a debt directly or indirectly to any person through any medium. 3. The term consumer means any natural person obligated or allegedly obligated to pay any debt. 4. The term creditor means any person who offers or extends credit creating a debt or to whom a debt is owed, but such term does not include any person to the extent that he receives an assignment or transfer of a debt in default solely for the purpose of facilitating collection of such debt for another. 5. The term debt means any obligation or alleged obligation of a consumer to pay money arising out of a transaction in which the money, property, insurance or services which are the subject of the transaction are primarily for personal, family, or household purposes, whether or not such obligation has been reduced to judgment. 6. The term debt collector means any person who uses any instrumentality of interstate commerce or the mails in any business the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect, directly or indirectly, debts owed or due or asserted to be owed or due another. Notwithstanding the exclusion provided by Clause F of the last sentence of this paragraph, the term includes any creditor who, in the process of collecting his own debts, uses any name other than his own which would indicate that a third person is collecting or attempting to collect such debts. For the purpose of Section 808(6), such term also includes any person who uses any instrumentality of interstate commerce or the mails in any business the principal purpose of which is the enforcement of security interests. The term does not include any officer or employee of a creditor while, in the name of the creditor, collecting debts for such creditor, b. any person while acting as a debt collector for another person, both of whom are related by common ownership or affiliated by corporate control, if the person acting as a debt collector does so only for persons to whom it is so related or affiliated, and if the principal business of such person is not the collection of debts. See any officer or employee of the United States or any state to the extent that collecting or attempting to collect any debt is in the performance of his official duties. D. any person while serving or attempting to serve legal process on any other person in connection with the judicial enforcement of any debt. E. any non-profit organization which, at the request of consumers, performs bona fide consumer credit counseling and assists consumers in the liquidation of their debts by receiving payments from such consumers and distributing such amounts to creditors. And F. any person collecting or attempting to collect any debt owed or due or asserted to be owed or due another to the extent such activity 1 is incidental to a bona fide fiduciary obligation or a bona fide escrow arrangement. 2. concerns a debt which was originated by such person. 3. concerns a debt which was not in default at the time it was obtained by such person. Or 4. concerns a debt obtained by such person as a secured party in a commercial credit transaction involving the creditor. 7. the term location information means a consumer's place of abode and his telephone number at such place, or his place of employment. 8. the term state means any state, territory, or possession of the United States, the District of Columbia, the Commonwealth of Puerto Rico or any political subdivision of any of the foregoing. 15 U.S.C. 1692b Section 804. Acquisition of location information. Any debt collector communicating with any person other than the consumer for the purpose of acquiring location information about the consumer shall, when identify himself, state that he is confirming or correcting location information concerning the consumer, and, only if expressly requested, identify his employer. 2. Not state that such consumer owes any debt. 3. Not communicate with any such person more than once unless requested to do so by such person or unless the debt collector reasonably believes that the earlier response of such person is erroneous or incomplete and that such person now has correct or complete location information. 4. Not communicate by postcard. 5. Not use any language or symbol on any envelope or in the contents of any communication affected by the mails or telegram that indicates that the debt collector is in the debt collection business or that the communication relates to the collection of a debt. And 6. After the debt collector knows the consumer is represented by an attorney with regard to the subject debt and has knowledge of, or can readily ascertain, such attorney's name and address, not communicate with any person other than that attorney, unless the attorney fails to respond within a reasonable period of time to the communication from the debt collector.